Good morning. This is Judge Alyssa Perez presiding over the 210 District Court docket for June 1st, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case?
On page 1, Judge, was number 2020 DCV 2323, Oscar M. Leiva Jr. versus Miguel Lucero Jr. et al. Announcement of counsel, please.
Ray Benavides for defendant Cordova.
I think we're missing Mr. Piñon. Is anyone here on behalf of Mr. Piñon or Mr. Wood? I don't see them. Mr. Marufo, had they logged on previously or?
No, Judge.
So I know you all had basically squared things away. So this was a status to check on finalizing the case. Mr. Benavides, have you been in touch with Mr. Piñon or Mr. Wood?
I have, Your Honor. So I believe that we're the cause of the delay. There was a check that was issued and lost in transmission. And so there was a stop payment ordered on the check and it has been reissued. And I believe the issuance occurred Friday, May 27th. So we're expecting, hopefully the plaintiff will get it this week, late this week, if not early next week.
Okay, so I'll go ahead. Do you know if they, I can't imagine, have we had any calls from Mr. Piñon's office?
I called 10 minutes ago, Judge. I left a message. Nobody answered.
Okay. If it's all the same, I'd just assume reset this maybe for 2 weeks. Mr. Benavides, do you think that's enough time or is 30 days better?
I think that's enough. I mean, as soon as we'll get it, the motion in order for dismissal or sign, we're just not going to file it until the plaintiff gets the money.
Sure. Okay, we'll reset for 2 weeks. See if we get that done. Thank you for appearing today, Mr. Benavides.
Thank you, Your Honor, for your time.
Take care.
Bye-bye.
Take care. Bye-bye. All right, who's next?
Top of page 2, Judge. In cause number 2020 DCV 3954, Manoraga Kumar Belau and et al. Versus Lorenzo Antonio Gonzalez et al. Announcement of counsel, please.
Good morning, Your Honor. Manny Morgan on behalf of the plaintiff.
Jose Vega here on behalf of defendant Gonzalez.
And Randy Grambling on behalf of the defendant Progressive.
Okay, and this is one I know I received, I think, an email with respect to a continuance, and I see that it was filed yesterday, I believe. So I don't know that. Let me go ahead and just take a look at it. Anyone have any issues with the continuance?
No, Judge, this is that case. I think at the last status conference, I explained that one of the minor plaintiffs unfortunately lost her life in this case. No suggestion of death has been filed. So we tried depositions. The dad went okay. The mom, I don't think that we weren't able to finish her deposition. We have an agreement that if the case doesn't settle, we'll go back and take her deposition. I'm assuming that if the case doesn't settle, Mr. James Kennedy will file a suggestion of death in relation to the minor. The case would automatically be stayed. We're set for mediation August 1st. I really do think that this case has a good chance of settling. If not, Judge, then with the death of the minor and what's going on, it probably wouldn't be ready to try until probably late 2022, if not early 23.
Okay, so I'll go ahead and look at that order, grant the continuance. What I would like to do, though, before we try and, I'm thinking in Spanish, adivinar, try and figure out what we will do with a trial. If you have a mediation scheduled for August 1st, I think I will set it for a status conference, a status scheduling conference on August 3rd at 10 a.m. And we'll see from there how best to proceed. Okay.
Did you say that you were thinking in Spanish?
Yeah, I said adivinar instead of trying to guess. I guess I don't know what sometimes the Spanish works better. Sometimes it doesn't.
I think so, Judge.
So we'll go for August 3rd. We'll consider that kind of a scheduling status conference. And so Myrna, we're canceling the 622, 720, and 722 settings. Am I looking at?
Thank you, Your Honor.
All right.
Thank you,
Thank
Your
you
Honor.
all.
Appreciate
Okay,
it.
we'll get you a
Thank you,
setting.
Judge.
Good luck. Take care.
Bye-bye.
Okay, who's yeah, we can do the, well, yes, because Mr. Anderson is here. Let's go ahead and take care of the criminal case, please.
In cause number 2018-0D05777, State of Texas versus Jacqueline Guzman. Announcement of council, please.
Greg Anderson for Ms. Guzman, ready to proceed, Your Honor.
So do we have Miss Guzman anywhere, either in person or, hi, Miss King, I forgot.
Hello, Judge.
Hi. Is she here either in person? Have you had any contact with her, Mr. Anderson? All right.
I'm
So,
not. Your Honor. She
Go ahead.
is, the family has had some contact with her, but unfortunately, we haven't been able to corral her enough to get her on a Zoom here.
Okay, so it looks like we've had a warrant outstanding since February. For my purposes, I did read, I know Carla's not here today, but I did read the case summary, and I think they're recommending BHRTC whenever we get to her. So there's a warrant outstanding. Once we catch up with her, then, you know, when you talk with her, that's basically what we're looking at, some type of modification to BHRTC.
I will attempt to get that message through to her and get her to turn herself in so we can hopefully resolve the deal.
Thank you very much, Mr. Anderson.
Thank you, Judge.
Yeah, you can be excused. Do we have any other criminal cases for today?
No, Judge, just.
I can let Miss King go do everything she has to do. All right, Miss King, thank you very much. Take care, guys. Okay. Who's next?
In cause number 2020 DCV 2902, Diana Morales versus Benjamin Lopez. Announcement of council, please.
Good morning, Your Honor. Joe Spencer on behalf of Diana Morales.
Good morning.
John Dickey on behalf of Benjamin Lopez.
Okay, good morning. So we're set for trial on a very busy trial day in July, but I'm seeing a vacation certificate, Mr. Dickey. Does that affect the trial setting, or where are you?
No, I'm ready.
Oh, okay. Okay. Mr. Spencer, are we on track?
We are, Your Honor.
Okay, so I'll give you all the heads up. Just for anybody else who has the 14th and 15th as scheduled trial dates, that was probably the last jury panel request that I had secured at the end of 2021. So as you can imagine, when we were going through scheduling, I have a ton of cases for those dates. Okay, so I'm just letting you all know that. I hear you, you're ready. I'm going to do my best to work through everything to whittle down my list of real cases to go, knowing that we have some coverage in terms of a referral docket. I may look at that, maybe a visiting judge that might require logistically creating more space. But I hear you, I have you down. I will mark you as ready to go, and we'll see how everything shakes out for those days. Okay.
Your Honor, do you have an idea of how much notice we'd have if in fact we're going to go or not? So
I'm gonna do my best to do it before the 4th of July holiday, because the court will be having some administrative days at the beginning of July around the 4th of July holiday. So I'm hoping to have July squared away in terms of all our trial settings before we leave on that break. So,
okay.
All right, I will do my best on that. I know that docket is particularly full. But the flip side of that is I also have several dates after that that are almost empty. So I will definitely check with you all. So thank you very much.
Thank you, Judge. Maybe
You may. Thank you.
thank you.
Who's next?
Up on page 3, Judge. In cause number 2021 DCV 3033, U.S. Bank National Association versus Margarita Munoz Martinez. Announcement of council, please.
Robert McLaughlin on behalf of the plaintiff.
Give me 1 second here. All right, there we are. Okay. Okay, scheduling status conference. Is there anyone here on behalf of Margarita Munoz Martinez, or have we had any communications from her? Myrna?
No, Your Honor. We have multiple attempts at service. We should file a motion for substitute service. And then assuming if there's no answer, we would then follow that up with a motion for default judgment. I would ask that we have another status in 2 weeks to 30 days, where we should have a motion for substitute service on file before the end of the week.
Okay, so my preference is that you go ahead and if you're gonna file it, and I will check in with a scheduling status conference in 60 days. So if you will
Okay.
email that to the court, I'll go ahead and sign off on it, and in 60 days, we'll see where we are.
Yes, Your Honor, we can do that.
Alrighty, perfect. Just send us by email your order. I mean, your
All right.
motion. Okay,
Thank you.
all right. Who's next, Mr. Marufo?
In cause number 2019, DCV 3681, Jaime Martin Ramos et al. Versus Gustavo Cardenas et al. Announcement of council, please.
Jorge Lopez on behalf of plaintiff, Your Honor.
Alfonso Soto for the defendants, Your Honor.
Okay, and this one, I did see there was a motion for continuance. I guess you have a conflict on the trial date, Mr. Soto, is that right?
Yes, Your Honor, I'm set for July 11th.
Mr. Lopez, what's your position on the motion for continuance?
I don't have an issue, Your Honor. We're actually trying to go to mediation. We had to cancel our mediation setting with Judge Villa. So we're trying to do it. I'm fine with that as long as we can get also, setting as soon as possible. And so
Okay.
we'll go all the way to July of next year. I don't know how your
No,
calendar-
I should be able to accommodate you this year. I hope
Okay.
I'm not jinxing it. But this is what I'm gonna do. I'm gonna go ahead and grant the motion for continuance with respect to the trial setting, which is also one of those July 15th settings. So cancel the 15th and the 13th of July. However, I do want to come back on that final civil pretrial in 2 weeks, because I want to know when you get scheduled for mediation. Once you
Okay.
get scheduled for mediation, I think what we'll do is if you know it and we want to try and get your trial date secured, we'll do that on the 15th of June. If not, I will set something shortly after your mediation. And again, if there's nothing outstanding, then we should be able to find you a trial date in 2022.
That's perfect, Your Honor. Thank you so much.
All right.
Very good, thank you, Your Honor.
Continuance granted. We'll see you on the 15th.
Thank you, ma'am. May I be excused?
You may. Thank you, Mr. Soto. All right.
Thank
who's
you.
next?
I'll call you, Mr. Soto.
Sure.
Bye.
In cause number 2021, DCV 2533, Richard A. Spoon versus Alan J. Arredondo. Announcement of council, please.
Robert Skipworth on behalf of the movement for consolidation, Your Honor.
Brian Little on behalf of the plaintiff Spoon, Your Honor.
John Dickey for defendant Alan Arredondo.
Okay, so I have here the notation on that motion. Had we not discussed it? I felt like we had discussed it previously, but maybe we had not had a hearing per se. Mr. Skipworth, go right ahead.
Yes, ma'am.
Mhm.
My clients, these cases are very similar. The Spoon case, the Ricks case, and the only difference in the two cases is the width of the driveway on either side of which Mr. Arredondo has encroached. Now he's encroached on Mr. Little's client's land, and then he's encroached on my client's land. And so the only difference in the two cases would be that we may have different surveyors who will testify, but essentially the facts are the same. It's just one driveway, not even 30 feet wide, that separates the two encroachments. And so we are moving to consolidate the cases. We think that would save the court's time, certainly save time and expense for the litigants.
Okay. And I saw the objection. I'm just pulling it up here. Mr. Dickey.
Yes, Judge.
Go ahead.
I disagree with Mr. Skipworth to the extent, I mean, we have two pieces of property on opposite sides of my client's property. Whether or not my client has encroached or has a legal right to ownership of the property on one side doesn't affect whether he's done the same thing, encroached, or has a legal right to ownership on the other side. The evidence, other than my client's piece of property, the evidence is not the same. There would be testimony as to how long my client has, whether my client has encroached, how long he's been there, whether he's got a claim of ownership through adverse possession on one side. The evidence on the other side is completely different. And my client may be successful or unsuccessful on one side, but not successful on the other side. And to consolidate these would be unfair to my client if a jury or however the trier of fact were to hear that my client's got claims on both sides, they may be more willing to think, hey, if he's done it once, he's done it twice, so he must be guilty all the time. And I don't believe it would be fair to my client to allow the court to consolidate this case. The cases certainly can be tried separately. And we believe it would be unfair to my client. And I've cited the cases that say the court can deny consolidation if they think an unfair trial will result. One of Mr. Skipworth's allegations in his motion is that you would have inconsistent results if you didn't try these together. And I disagree with that because as I said, the results on the side as to Mr. Little's client are completely different than they are for Mr. Skipworth's client. And I don't believe it would be fair to my client to allow this case to be consolidated.
Okay,
So
Mr. Skipworth. Sure.
Yes, ma'am.
Mr. Skipworth, what other similarities, or other than there being a common property owner, Mr. Arredondo, how else are these two cases similar?
Well, the defenses that Mr. Arredondo is going to put forward are the same in both cases. It's going to be essentially the same evidence in both cases for the defenses. And I don't know, maybe the parties may be able to agree on one surveyor. So it'd be one surveyor to testify about the encroachments on either side. But seems to me, I don't know if the court enjoys listening to these cases, but it's going to be a situation where you've got two trials essentially for the same area, same driveway.
Okay. All right, anything else?
No, I have nothing else to add, Judge.
Your Honor, if I may just briefly, I represent the plaintiff in this case, and I also believe there is a commonality of legal issues that need to be addressed. I do believe that the underlying property was owned at one time by one single individual, so you have a commonality of underlying ownership. I think that property between Mr. Skipworth and Mr. Dickey's clients was ultimately subdivided by one individual. In addition, Judge, these are not issues that have been predicated on tacking or anything like that. It's not like there are any issues related to previous ownership. It's really Mr. Arredondo making a case for his own adverse possession or ownership of the pieces of property that are adjacent on both sides of him. And so I think in the interest of judicial efficiency, it would be because of the commonality of legal issues that the jury will address. And yes, they will get two separate sets of questions for Mr. Skipworth's client and for our client, because there will be some differences because there are two separate pieces of property, but the commonality of legal issues, I think, necessitates consolidation.
Judge, I disagree with the commonality of legal issues is not enough in this case to combine the two cases. And again, it would be unfair to my client. Again, my client does have the piece of property. That's the only commonality. And as Mr. Little already stated, there'd be two separate questions. Yeah. One did, with regards to Mr. Little's client, one with regards to Mr. Skipworth's client. And whether we have encroached or have a right to ownership again on one side doesn't mean we did or we did not on the other side. So we believe it's unfair to my client to allow these to be tried together. So I'd ask court to deny it.
Okay, is there anything else?
No, Your Honor.
Mr. Little,
Nothing.
Mr. Seaforth?
Nothing further.
Nothing further, Your Honor.
Okay, so I'm going to deny the motion to consolidate based on the issues raised by Mr. Dickey. Mr. Dickey, if you have a proposed order denying, please send it over for the court signature.
I'll circulate that to Mr. Skipworth and Mr. Little.
Thank you very much. Thank you all for your time. You all are.
Thank you, Judge. May we be excused?
Yes, thank you. Who's next?
In cause number 2021 DCV 3771, Yuri Hernandez versus Jennifer Amaro. Announcement of council, please.
Did we lose? They were here. Oh, no, there's Mr. Gramley. And oh, and there's Ms.
I'm here for the defendant.
Labinati?
She can't.
Sorry, Judge, I am multitasking, so that's what happens, right?
No worries.
I
Yuri
apologize.
Hernandez, we have a scheduling status conference.
Yes, Judge. I saw Laura and the Zoom and I was like, oh, I owe Laura something. So I have to
That's the Laura. That's the Laura
like,
effect on my Zoom hearings. You see, Miss Enriquez?
Sorry, I'm
just-
taking on Laura. It's not Laura's fault, but I just thought, oh, let me just send it to her since I saw she reminded me.
You're present.
Good morning,
All
Your
right.
Honor. Daniela
So
Nevialti for the plaintiff.
Wonderful. We're here to get a trial setting and get your scheduling done. I see we've reset it though from April. Was there something going on? Were we waiting on something? Potential resolution?
Judge,
I don't know.
We are waiting on Randy to answer my office for setting up deposition and mediation. So, Randy?
Danielle, it's a new case.
Okay, all right. Well,
if you want to set that, yes. Are we looking for a trial setting next spring?
Yes, that's
Whatever
where
the
we
timeline.
are. I'm thinking we're heading into, and maybe Myrna, you can help me with a date here. I'm thinking maybe something in April. What are we? We're already June. I mean, in old days, we do June of, 1 year out. Do you need a year? Can you do less than a year?
April's fine, Your Honor. I settle everything with Danielle anyway.
whatever Randy wants, Judge. How about that?
Look at this. I love it. April 21st is your trial setting. We'll get you the scheduling order. Do you all know who you are using? Or it sounds like you're already talking about mediation. So
Whatever Daniela wants, I don't care.
Well, either Judge Via or Moss. I only use those two, Judge. So that's pretty much okay with me. I can try a case with Randy because he said the day that I try a case with him, he'll get me chocolates and move my chair. So I know I'm going to lose that trial.
all right.
He's going to be too nice to me, Judge. He's going to be too nice.
We have a trial date. If you all will get us the scheduling order with your mediator back in 2 weeks. And we'll be good to go.
All right.
Thank you.
Thank you,
Thank
Judge.
you.
Judge, I have another hearing with, I don't know if I still have to appear. It's on Sylvia Cortez. JL was supposed to send the scheduling order that both me and Mr. Paxton approved, but I don't know if I'm still.
I believe it's been taken care of because it was
Okay.
marked as canceled on my docket.
Okay, so I can get off. Okay, thank you, Judge. Thanks,
Thank
everyone.
you. Take
Bye,
care. Who's next?
In cause number 2009-1174, Dodeca LLC versus Marta Roche. Announcement of council, please.
Yes, Charles Kennan for the plaintiff. And Your Honor, I need to move out there with you all. You're a lot more fun normally than what I have to face here. So I'm going to start packing real soon.
It's not fun every day. Some
I
days
know.
it's fun.
This one though kind of is. After all our many visits, I just wanted to advise the court that we have got a signed settlement agreement with the defendant, Ms. Roach, and I would simply ask that our motion to revive be granted so that we have like the underlying judgment to hang our settlement on, so to speak.
So we have had many kind of resets, a lot of different things. If you have previously sent over, emailed that document for me to sign, I assure you, there's no way I'm going to find it. So if you would kindly email.
I totally respect that, so we'll send a new one.
Thank you very much. We'll take care of that. Yeah, just send it over. I don't think we need to have another setting.
Okay, thank you, Your Honor. I appreciate it. If I may be excused then.
You may. Thank you very much.
Thank you. Bye.
Bye-bye. Who's next?
In cause number 2020 DCV 1774, Hector Sarasua versus State Farm Lloyd's. Announcement of council, please.
Kelly Harefield for the plaintiff, Your Honor.
Laura Enriquez for the defense, Your Honor.
Good morning. Final status conference. You have our wonderful July 15 trial date. How are we doing?
We are
have not
trying to,
mediated, Judge.
right.
Great. When are you all set?
We are not set, Judge. We are not set for mediation, so we need to set the mediation up. But Judge, I have another issue. You know, Mr. Soto just came on and said that he had a trial on July 11th. So I am trying that case with Mr. Soto and Judge Frank Montalvo's court, and
Sure.
it's the entire week. And it was a Judge Martinez case. It's like one of the oldest cases, and it involves Mr. Chavez and a lot of other people. So I do think that is going to be going on. And so I did want to let the court know that, and also plaintiff's counsel, Judge.
So this, it sounds like we have some things outstanding. I see some pleadings here that have been filed. A lot of movement. I think it's really, Ms. Hodge, do you have any issue with the continuance? I'm thinking of that setting.
No, I do not.
Okay. So I would ask you this, if you all will someone file an agreed motion for continuance, I will grant it and you can consider it granted right now. Just get something filed, please. And that way I will cancel out the 13th and the 15th. What I would like to keep again is that June 15th final civil pretrial. So I can find out from you all when you have your mediation scheduled. And then I'll take my cue from you all. If on the 15th, you're ready to try and, assuming we don't get things settled at mediation, have a trial setting that we can secure you for 2022. If not, we'll just wait until after mediation, but that will probably push us back into 2023. Okay, sound good? Okay, so we'll see you all on the 15th. Is that good?
Yes, thank you, Your Honor.
Alrighty.
And I'll, Your Honor, I'll take care of doing the motion and sending it to plaintiff's counsel.
Thank you very much. Appreciate it.
Thank you, Judge. Bye-bye.
Take care, guys. Bye-bye. Who's next? I see Mr. Gutierrez's
Yes.
screen, but I don't see him.
In cause number 2021 DCV 2563, Portfolio Recovery Associates LLC versus Luis Taquini. Announcement on council, please.
Benjamin Joseph Gutierrez on behalf of Portfolio Recovery, ready to proceed on motion for default judgment, Your Honor.
Oh, okay. Well, wait a minute. We have, what happened here? I'm seeing there's two motions for default. One that was just filed a few days ago.
So one of our trainee clerks accidentally accepted a proposed order for default judgment. So one of those is unsigned.
Okay, so our original one is from April 28th. So, or April 21st, there's actually three.
Three, yes.
Okay, so at least on the April motions, did you notify Luis Taquini and there's nobody here, right? Do we have proof of service, notice of the hearing?
Yes, Your Honor. And this one I did verify this morning.
Okay, so, and just to be clear, Mr. Hernandez, Mr. Marufo, we don't have any contacts from Luis Taquini?
No, ma'am.
Okay. All righty. Mr. Gutierrez, you may proceed on your default.
May it please the court, Your Honor, we're asking redress in the amount of $1,880.53 plus court costs and post-judgment interest. And this matter happens to do with the Citibank credit card that was stopped as a home furnishings credit card ending in 9783. The account began back in March of 2019. We're asking the court consider and enter into evidence the business records affidavit from a Miss Costa Thomas. Therein, Miss Costa Thomas attests to the account, the delinquency of the account, and the grounds for the redress that we're seeking. The affidavit is from May of last year. The last statement, the last payment date was in March 26th of 2020. The account was charged off in October of that year. Miss Acosta Thomas further provides an affidavit of sale and such of the account. The petition was filed in July of last year. The defendant was served the following month. And as the courts denoted, there's up to 3 motions for default judgment that are for its consideration that are before it. And the notice of the hearing was provided to the defendant. The USPS tracking number shows that the defendant received it on April 25th of this year. We also have the certificate of last known address and SAC information and an affidavit of non-active duty military status for the court's consideration, Your Honor.
Okay. And I did review the motion. What I would ask, the default will be granted. I am having quite a bit of trouble with my email right now, so I may need you to resend the conforming order, but attached to that, I would also like a copy of the confirmation on notice. So the information that you provided with the tracking, whatever document you have there, just send it on over as an attachment to the order, and I'll go ahead and sign off on it, okay?
Understood, Your Honor.
Thank you very much.
Thank you very much.
Anything else, your excuse? Thank you. All right, we can get off of YouTube.